I think so. And here's, if you like, one of the ways in which the post office case, it may be a kind of symbolic or a particularly bad example of things that go on more generally with clients who aren't as sympathetic as, or defendants who aren't as sympathetic as the sub postmasters, to go back to one of the points at which we came in. Which is that prosecutors and judges can be quite dismissive of the rights of the defendants in these cases and regard it as a stalling tactic or a delaying tactic case, when they're all eyes are, if you like, on horizon and protecting horizon. What they do is not disclose the information about an absolute catastrophe in terms of litigation management. Lots of really quite serious criticisms. I am a law professor. I did qualify as a solicitor many years ago and practiced for a little while, but most of my career I've spent teaching and researching. And what I research is access to justice, lawyers ethics. So, and they're obviously areas very much on point in relation to the post office problem. So that's what I spent, if you like, most of my adult life reading about, interviewing people about, collecting data on, and writing about.
And you're based in Exeter, and you are part of the lab, the Evidence-Based Justice Lab. Is that right?
That's right. So the lab is a creation of Rebecca Helm, Dr. Helm, and Rebecca is a criminal lawyer and psychologist by training, and she is particularly interested in miscarriages of justice and also, if you like, some of the law and psychology ideas behind why things go wrong. I suppose you could put it in those terms.
Yeah.
And there is a third member of the team who has actually just started working at UCL in London, and Karen Noakes, Dr. Noakes. And Karen is somebody who comes, had a lot of experience as a solicitor and used to work for the solicitors regulator, but has transferred into academic work, again looking at ethics and culture insofar as it impacts on lawyers' behaviour and decision making. I suppose you could put it in those terms.
And the three of you are looking at the post office. You've called it the Post Office Project on the website for the lab.
Yeah.
And what exactly are you most interested in?
So the thing that I'll probably spend most time talking about today is the ways in which lawyers' behaviour or decisions not to do things, if you like, have contributed to, even perhaps been a central feature of, the behaviour of the post office and the miscarriages of justice that the sub-postmasters and their colleagues and sub-postmistresses have suffered, both in terms of criminal process and beyond that even. So that's probably the thing that I'm particularly interested in. We're also very interested in what the case tells us in general about miscarriages of justice, how the victims of miscarriages of justice experience the legal process, and both the criminal process and the civil process, and their dealings with lawyers more generally. And we're also interested in the relationship between corporate culture, organizations, the way organizations do things, and the way that lawyers behave. So we think that there are sites. So to give you one example, the post office case looks and feels like an instance of corporate hubris or arrogance, if you like. There's been lots of management work on that, and we think actually the way lawyers behave might contribute to that problem in various ways. So those are the three things really: corporate culture, miscarriages of justice, and lawyers' behaviour, lawyers' ethics.
And you've very helpfully put on the website two of your publications already that people can download.
Yeah.
And so can we deal with the first one, and can you give us some idea of what you're covering?
So the first one, we look at essentially issues arising from the Bates litigation. So for those who don't know, the Bates litigation was a group litigation brought by, I think, 555 or so sub-postmasters and their colleagues against the Post Office in relation to the problems with Horizon and the impact on their lives. And the judgments in those cases come in at, there are 6 of them, they come in at more than 300,000 words. Mr Justice Fraser was the judge, and he dissects the behaviour of the Post Office and the behaviour of the lawyers in quite minute detail. So essentially what we do in that paper is draw out the parts of that that are particularly related to the conduct of the litigation and particularly related to, or that might be related to, the conduct of the lawyers, and suggest ways in which that might merit professional investigation and perhaps in some instances professional prosecution. So we're basically trying to say, this is what Mr Justice Fraser says, this is what we think the lawyers might have got wrong, this is why it needs further investigation. Can you give some examples of that? I can. There are dozens and dozens. It's really quite an extraordinary document, an absolute catastrophe in terms of litigation management. Lots of really quite serious criticisms. So it includes things like the pleadings, so the documents that are drafted by the lawyers with the instructions of the client to tell the court what the case is. Those pleadings were said in some instances to be misleading by the judge. The witness statements for the Post Office witnesses, a number of those were said to be misleading by the judge. Now, the interesting question there is who's responsible for that? Is that the lawyer's responsibility or is that the Post Office's responsibility? And the likely answer is a bit of both, of course, but there is in significant part a question about what did the lawyers do to make sure that the witness statements were accurate and so on and so forth. You had in the trial, as we read it in the judgment, witnesses disowning large parts of, or certain significant parts of, their witness statements as they gave evidence, saying they hadn't seen things or whatever it might be, in ways which suggest either the witnesses were just telling fibs or the lawyers hadn't properly prepared those witness statements with the witnesses. The judge suggesting, he only suggests, he doesn't decide, that the witnesses haven't actually drafted those statements themselves. They're not written in the witness's own words. They're not based on the witness's own experience. So there's that big set of problems around the court essentially being misled by omission or commission by the Post Office and or Fujitsu and all the behaviour of the lawyers. That's probably the biggest thing. Although they will have signed those statements, obviously, won't they? Yeah, the witnesses would have signed them. They should have read them. Yeah. They should have been heavily involved in the drafting of them. And the suggestion is that somewhere along the line, something went wrong. There's a very curious thing which feels almost conspiratorial the way it's put by the judge, but I think it is worth highlighting. The judge draws attention to a group being responsible for litigation strategy in relation to the case, that group didn't include the lawyers instructed for the Post Office. So you've got a separate group somehow or other running the case, and it's not clear to me who was in that group, whether that group included any lawyers whatsoever, and why it was them dictating strategy rather than doing so in collaboration with the lawyers. There's something very odd going on there. There were routine refusals to provide disclosure of evidence, which the judge said was refused on grounds which weren't available to the lawyers for the Post Office. So there's those kinds of things. One other thing that I guess I would sort of mention front and center, which raises lots of really quite interesting sort of technical issues, which we could get into if you want to, but we might get a bit too sort of off the path for your listeners. But there's a man called Gareth Jenkins, who people who follow the case will have heard that name any number of times. He's the subject of one of the famous Clark advices, which we'll probably come to when we discuss the criminal cases. Gareth Jenkins was an employee of Fujitsu, and he was put forward by the Post Office in some of the, only a handful actually, of the criminal cases as an independent expert. He wasn't independent, he was an employee of Fujitsu first and foremost. He was involved in the running design of Horizon, I think. I'm not sure about whether he helped design it, but anyway, he was an employee working for Fujitsu, gave supposedly independent expert evidence. In 2013, his evidence was discovered to be significantly flawed, such that a lawyer advised the Post Office that he had probably misled the court. Jenkins does not give evidence in the civil case, and it's a mystery as to why he does not, but it becomes clear in a number of ways, some which are transparent, if you like, and some which are hidden or not transparent, that Mr. Jenkins has been providing a great deal of the information that Post Office's witnesses have been giving to the court. So they have a source of information found in criminal cases to be unreliable, if we can put it in those most general terms, or at least found to be unreliable in 2010/13. Still giving information, feeding information to the Bates litigation and not being called to give evidence, not being subject to cross-examination, and large parts of that evidence eventually being found by Mr. Justice Fraser, the judge in the High Court case, to be unsound or wrong,
and is that,
etc., etc.
Is that part of which would be the robustness of the system? You know, it's a robust system. Is that?
Yeah. So, yeah. I mean, in a nutshell, what the Clark advice says about Mr. Jenkins is that he is giving evidence to say that this is a robust system, giving the impression that it's infallible, and yet he knows about two particular bugs, and he knows about the fact that remote access was possible. So it's possible for Fujitsu employees to access the system and change it without some postmasters necessarily being aware of that. So he knew those things, and yet is giving evidence that it's infallible to the court, or giving the impression that it's infallible. And that is, or could be thought to be, misleading. And yet the same gentleman is giving evidence by proxy, if you like, and that's my phrase, not Mr. Justice Fraser's, but giving evidence by proxy through the witnesses that he is feeding information to in terms of the Bates civil litigation. So that's a really substantial problem with the way the case was run. And the judge says, actually, it's quite interesting, there's not a great deal I can do about this. It's up to the Post Office what witnesses they call, and I can just assess the evidence on the basis that I see it. But he does avert to this problem with Mr. Jenkins giving evidence in the background. And as we know, some Fujitsu employees, including him, were referred to the DPP and Met Police for investigation. So there's all this stuff going on in the civil litigation. The more general, tell me when to stop. The more general problem was that and again, this is my phrase, not the judge's phrase, there was a kind of scorched earth approach to the litigation. So the Post Office threw maximum resources at the case, argued points which the judge regarded as untenable or unreasonable reasonably frequently, or certainly that's the impression you get from the judgments, with the effect of, if you like, building up the costs for themselves and for their opponents, making it harder for the claimants, the sub-postmasters.
Knowingly and deliberately.
Well, I think that's the impression the judge has.
Yeah.
And it's a common tactic by large, well-funded organisations to people refer to it as bullying their opponent into submission by simply outspending them on every opportunity, drawing the case out. To give you one example, they agree it's a group litigation order in the end, that's agreed, and then they continually run arguments which effectively try to unpick that decision of the court before the court itself. It probably reached its apotheosis, its kind of summit, if you like, when they tried to get the judge recused, so kicked off the case for a bias or apparent bias halfway through the second major trial. And they sent in a leading barrister, Lord Grabiner, to argue the case for them. If you read the transcripts, Interestingly, the barrister representing the post office in the case itself doesn't appear to know what's going on when this is going on. So this might be another example of, quite extraordinary example of one team running the case and the other team presenting the case. But Lord Grabner is brought in to argue that the judge should recuse himself, take himself off the case, and they are unsuccessful. The judge says no, and then in quite extensive terms, then they seek leave to appeal, post office seek leave to appeal to the Court of Appeal, and the Court of Appeal says no in quite extravagant terms, really very critical. I'll see if I can get it up quickly for you in case some of the words are, because it's entertaining if not illuminating. Well, it is illuminating actually as well. So Lord Justice Coulson describes the leave to appeal application, the recusal application, as without substance, misconceived, particularly egregious, says it significantly misrepresents the case that was before the court, etc., etc. Parts of the application wholly unjustified, wholly unpersuasive. The application described as discourteous and showing a singular lack of openness. Even says one of the exchanges between counsel for the post office and the judge was an attempt to presumably, they say, put the court in terrorium, which winter, I can never pronounce Latin, my apologies.
In terror.
Effectively to try to sort of intimidate the judge, a very extraordinary thing for a Court of Appeal judge to say about. I personally, I thought that was that last remark was a little bit over the top. Grabner says, "Oh, well, we've taken advice from some very senior lawyers, and the kind of implication is it might be, say, an ex-Supreme Court judge, who knows, and they say we're right, and it's kind of like, my dad's bigger than your dad kind of approach to it. It's a bit childish in a way, but the Court of Appeal nonetheless takes the opportunity to give them a bit of a ticking off for that tactic." So,
do you think, Richard, that people like Lord Grabner would actually know what they were doing and know the situation they're walking into with the Court of Appeal, or do you think they actually believe what they're saying? I mean, obviously barristers to some extent get wound up and set off to go like clockwork, and they have to do what they're instructed. But on the other hand, they presumably have to some extent, accept that it's a reasonable thing to do, ethically and professionally.
Well, yeah, so it's a really interesting question, this one, and this applies to all the lawyers involved in the cases, particularly those who appear before the court. But there's a Court of Appeal case called Faruqi, which is actually a case about representing a terrorism suspect. And in that case, the Lord Chief Justice of the day, it was Lord Chief Justice Thomas, if I remember rightly, might have been Judge, anyway, can't remember. The Lord Chief Justice says that lawyers take responsibility for their strategy before the court. They cannot simply say they are relying on their client's instructions. They're not just doing what the client tells them. So in that sense, it's true. It's a bit more subtle than that, though. So there's a sort of a question as to whether the arguments Lord Grabner was making were sufficiently plausible to be made, and that's quite a low standard to make. You can make most arguments without getting to ethically difficult territory. I'd have expected Lord Grabner to try to familiarise himself up to a point with the basis of the application and what's going on, but he'd have only had, unless he'd been involved from the beginning to the end, he'd have only had a limited opportunity to do that, and he's asked to make the application, and therefore he under the cab rank rule he makes the application, but he decides how to make it. So the my dad's bigger than your dad point, for instance, that's his decision, I think, and if he'd done something he shouldn't have done, then he would be accountable for that. There's an interesting question about whether he could or should say, actually, this shouldn't be brought, this application. And there's an interesting question about whether the independence of Lord Grabner and or the barristers representing the post office in the main litigation are being undermined by this kind of twin track approach. And I think it seems to be very interesting that the first team didn't appear to, if the transcript is accurately capturing what's going on, didn't appear to know about the application being made, or at least being made at that point. So,
and my experience,
sorry
to kind of,
no, go ahead.
But my experience of being cross-examined as an expert witness has been in the family court, has been that sometimes the instructing client wants the lawyers to say most unreasonable things, to argue most unreasonable things. And when you're facing the barrister, you can see from the way they ask the questions that they are simply acting as a mouthpiece. And they will say as much. My client wants me to say, or wants you to answer this question. And the non-verbal language is transparent, and everybody facing the barrister can see it, which means the judge as well. And so it's clear that people struggle with this and have to follow their instructions, but clearly also have to have their own standards to live by and work by, which is
that's right.
In medicine, of course. You can be asked to do a medical procedure and you have to decide whether it's ethically proper to do what the patient wants.
Yeah, and the Faruqi case does emphasize that actually the lawyers cannot simply say I'm instructed to do it, therefore I do it. They have an independent judgment about how to do things and sometimes what to do in terms of the conduct of the case. And what the Post Office did is they split out a bit of the recusal bit of the case. They split it away from the Team A and gave it to Lord Grabiner, who would have only had a limited period of time to get on top of it, and he ran the application for good or for ill.
How do you think this might be? Sorry, Rich, I keep interrupting.
No, it's good.
How do you think this might be unpicked? Because clearly, at the moment, you're looking into a kind of black box with a certain amount of information coming out of it. But there's a lot of complicated things going on within the Post Office in this process, and somehow that needs to be understood if anybody is ever to be held to account for what they've done. How's that going to happen? Do you think?
Well, so the Williams inquiry is one possible avenue. And so one of the reasons for doing the work we've done and trying to get it done as quickly as possible, get an initial view out, is to try to say to Sir Win Williams, look, these issues actually are a central part of the problem. So lawyers were being used consciously or unconsciously, if you like, because I think a lot of this is just normal corporate behavior, kind of reputation management type behavior, being used to manage the view of Horizon from 2000 onwards, but particularly from sort of 2010 onwards, and were central to and winning the Bates litigation was part of that. Resisting disclosure in the criminal cases was part of that, whether the lawyers quite realised how they were being used or not. And it's a central part of the problem. So the Williams inquiry should be looking at these things. There are elements of conduct. Actually, so Lord Grabiner's, I talk about that one because it's a nice juicy story, but that's not the most interesting or concerning example of, if you like, problems with the lawyers' behaviour. There are far more in the Bates litigation where I think the lawyers involved will need to be investigated and thoroughly investigated by their regulators, be they the Bar Standards Board for one or two of the barristers and the SRA for the solicitors, working in-house within Post Office and Fujitsu, for instance, but also some of the ones involved in the conduct of litigation themselves may also need to be investigated. So you'd expect between those two avenues for there to be fairly full and thorough investigations. They only come out, the regulators' investigations, if there is a prosecution. So otherwise we won't hear what was found or discovered. So I'm hoping that Sir Win Williams will take it seriously and really get to grips with who knew what when and did what in relation to the lawyering on these cases, because to me it's a central part of the story and the problem that the sub-postmasters have faced.
One of the most extraordinary things is we've been speaking to somebody called James Christie, who started out working as an accountant, was trained as an accountant, and then moved into IT, and he's worked for some pretty substantial companies, and he's been an auditor, and he has given us one interview already that we've published, and another one which we did yesterday, which we'll publish soon.
Yeah.
He is absolutely clear that anybody who works in IT would know that a software program like Horizon could not be described as a large, what was it? A large calculator, which is one of the explanations that Wendy van den
Bogert, yeah,
gave it in the litigation in one of the statements, apparently. And
right.
It is amazing to think that if it's so simple, and a lot of, anybody involved with IT should know that. It is amazing that so many people have been
and the point being that there's an assumption that computers are reliable, or at least there was an assumption that computers are reliable. What came out of them could be trusted without question.
But it's amazing that we could spend so many years, so much money, harm so many people, when actually Jenkins must have known what James Christie knows. How do we understand that, I suppose, is my question.
So I may not be the best person to try and answer that, but I'll give you my feeling for what it's worth. At one level, you have a lot of people who are familiar with the system and with running software systems, and they will know that there are mistakes and errors occur and they're corrected, and they will think that they're being corrected or hope that they're being corrected. There may be a degree of wishful thinking about what was going on. And so they feel that they can say, well, basically the system's fine. And of course there are mistakes, but every system has problems. The system is basically fine and robust. You could have those two ideas running side by side, and you could present it in those terms without necessarily being right or wrong. The key question is, how serious are the problems that actually are going on under the surface? How impactful are they? And it seemed to me that Post Office / Fujitsu, so I'm not quite sure how far responsibility was shared or any lay with it, Fujitsu, for instance, but I think probably it was reasonably well known by both. They had a sense of there were some substantial problems, but they were being told they were being fixed, or they were fixed, or they didn't affect the particular branches or whatever. There was always a series of excuses or explanations or fixes offered which should have resolved the problem. And you could imagine how the managers and the people giving evidence would take the view that this is just part of the everyday, and it's all fixed, and it's not substantial, and it doesn't mean that. You can imagine how they might think like that for a period of time. I guess one of the questions is, at what point does that view become untenable? And one of the things that I think is interesting, I don't know if did you say James, Christy?
Yeah, James.
So James talked about this. Is that I don't know what knowledge there was of IT systems on the board, for instance. And actually, one of the things that's been said to me by people who, if you like, understand board dynamics is you really need some expertise at the board level when you're dealing with this kind of thing. There was a fairly clear sense that even relatively senior people didn't really understand what was going on, or if they did, then they were perhaps being more misleading than one would like to think possible. So there's a whole set of those issues. At what point did the problems become so serious that they can't ignore them? I think the other thing that's kind of going on is they saw it in quantitative terms. So they thought, well, we've got, however many, 18,000 branches, however many it was, 6 million transactions a day. Of course, you're going to get some mistakes in those, but they're a tiny number, and therefore we can ignore them. You could imagine how a manager might think like that.
Yeah.
And what they're forgetting is it's those tiny number of mistakes, if they were tiny, that were leading to this kind of cascade of financial carnage for the particular branches and the particular sub-postmasters or sub-postmistresses. And they didn't have any system for coping with understanding, investigating those properly. They just said, brush them to one side. So the auditors couldn't properly grapple with them. The investigators, when they were interviewing sub-postmasters, didn't grapple with them. and the next tier of managers, when they were starting to think about reviews and so on, and whether the cases might have gone wrong, so 2010, 2013, none of those grappled with them. They put them either in the too difficult box or we don't believe them box, because the numbers suggested to them there wasn't a problem. That's that if I'm trying to think as kindly as possible as to what might have gone wrong, I'd put it down in those terms.
Well, James goes into it in quite some detail, so we'll publish that soon, and I think people will find what he has to say interesting. Yeah.
Well, a £30,000 deficit for a sub-postmaster is life-changing, but is utterly microscopic as far as the post office turnover is concerned. So the importance of the problem looks very small at the corporate level, presumably. It's massive down at the personal level.
It wasn't so small that they weren't willing to go after them for the money.
Well, this is the paradox, isn't it?
That's the kind of thing. And they just took the view that these people are liars.
Yeah,
that's the view they took. So they ignored everything they said. And when we get into the when they were being prosecuted, investigated and prosecuted, they had particular obligations not to do that.
Well, I think we should talk about that, because these people that we've spoken to don't look like your average, can I say this? Your average criminal. They've obviously been vetted before they became sub-postmasters. They're not wearing Rolexes or driving cars, luxury cars. Nobody's found any money hidden. So if they are criminals, they're master criminals, because they're hiding their ill-gotten gains somewhere, which nobody seems to be able to find.
Yeah.
And they don't seem to be behaving like fraudsters, in the sense that they're often trying to pay the money back and looking in a terrible state of anxiety about it.
Yeah.
They are ordinary working people. That's our experience, who are genuinely seeking out what could have gone wrong. They're spending hours, some of these people, going through their own documents, trying to work out, how it could be that they've got this loss. They don't believe it's their fault. They're spending, nights and nights worrying about it. These are not the kind of people that you routinely see at a police station, from my experience. And I did do 10 years of crime. So, I have done quite a bit of it. And then they're not the kind of people that you routinely see.
No, I think that's one of their when you listen to the interviews in the media, they remind you of your mum or your dad or your uncle or your brother or whoever it might be.
Postmaster.
That's one of the most powerful things when you listen to them. You hear about them talk about things mainly without any rancor. I do think it's absolutely
amazing.
Really extraordinary.
And yet they were treated as though they were, hardened criminals.
Yeah. And it's the sort of, in a way, that's why they're so persuasive to the outsiders now. What was going on at the time is that they were offering up explanations, and sometimes, and the post office just ignored, in the main, just seems to ignore the possibility that actually something might be going wrong, not investigate it, even sometimes when the evidence of their own investigators suggests there may be problems with the prosecution, they proceed. For all the flaws in the way the investigators did their work, even then, when they turned up problems for the post office case, they steamrolled on, certainly from the cases that we've seen, when there may be some where that isn't the case. But it is quite an extraordinary, it's a sort of bureaucratic corporate juggernaut which just drove over these people's lies, because they couldn't countenance the idea that Horizon was wrong. Therefore, these people must be lying. Therefore, we'll have the money back. And if we don't get the money back, we'll prosecute these people. It was that kind of awful inevitability to it.
And you've been looking at the criminal prosecutions, I think, and looking at themes arising there.
Yes.
What have you been kind of picking out from that?
Well, so it's the sort of again, we've mainly relied on what's in the Hamilton judgment. So those people who've read the Hamilton judgment, some of this will be very familiar. So there was the problems with the investigative process, people not being able to have representatives interviews, the way in which those interviews were conductive. So the kind of Spanish Inquisition approach, you must be guilty, mustn't you, rather than an investigative approach, but trying to bully, intimidate, threaten people into admitting their guilt. Investigators clearly not sufficiently prepared for the interviews in some cases, so don't know the basic facts. Didn't understand how Horizon worked, some of them, according to parts of the Bates and Hamilton cases that I've looked at. So there's all that stuff. The decisions to charge. So lawyers are supposed to charge. If you're a prosecutor, you're supposed to charge where there's sufficient evidence to bring the charge. There was no evidence of dishonesty for particularly the theft cases, possibly the other elements of the offences charged as well, but particularly the theft cases. That was sometimes on the face of the file. The investigators said there was no evidence of dishonesty, and yet post office lawyers, and these were post office lawyers internally, deciding to proceed with those charges anyway. The plea bargaining then taking place in a way which is designed to get a plea, restrict any criticism or prevent any criticism of Horizon, a kind of sort of ancillary aim, which is probably not legitimate, shouldn't be restricting people's mitigation in that way. So a whole bunch of problems with the way the prosecutions were kind of structured beginning to end. Disclosure of evidence, again, like the civil cases, routine refusal to disclose evidence on the basis it wasn't relevant or that it cost too much or whatever it might have been. So that happened in a sort of regularly. They would just try to resist disclosure of evidence, and a failure to, and this is the point I was making briefly earlier, a failure to investigate reasonable lines of inquiry. So where the sub postmasters were saying, well, look, there was a problem with the hardware and this happened, or this, they didn't investigate those kinds of leads, if you like, and they are obliged to, as a prosecutor, to follow to make all reasonable inquiries, whether it leads to prosecution or, if you like, successful defence. Those kinds of problems in the way that the initial prosecutions were conducted. The worst example, in a way, is the one that gets the most detailed attention, is the Seema Misra case, so Mrs. Misra's case, and in her case goes to trial in 2010. Her lawyers have been requesting proper disclosure for many months. In fact, an original trial was moved to 2010 for that reason. They keep requesting disclosure, they keep getting resisted. The judge eventually just says, we're going to carry on with the trial regardless. Slightly extraordinary decision, one would say, with the benefit of hindsight at least. And we know that just before that trial was when the two particular bugs come to the attention of Mr. Jenkins in Fujitsu, and those bugs are discussed, and it looks to me from the documentation like some information about that also went to the criminal lawyers within the post office, if I've understood the judgments and the facts in the judgments correctly. And so the lawyers in the post office, in the criminal department, know about, or at least sent the information about it. They regard this trial as a kind of a must win because it's the first case where there's an expert really ready, if you like, to take on the post office. And mysteriously, that information doesn't get disclosed to Seema Misra's lawyers. And she is eventually convicted and she's sent to prison.
Whilst pregnant.
Pregnant, as you know. So
yeah.
That's a fairly extraordinary set of circumstances. When they know this case is a really serious case, when all eyes are, if you like, on Horizon and protecting Horizon, what they do is not disclose the information about the bugs that had come to light. And it's that, and Mr. Jenkins gives evidence at Mrs. Misra's trial, as I understand it. So it's that in 2010, that's what becomes the subject of the Clark advice in 2013. So you have this kind of thing, that's the worst example, this kind of thing going on, presumably through the life of the cases from 2001, 2000, when the first one was brought through to 2013, when in the main these cases seem to have stopped. You get then to what happened in 2013, and there was an awful lot going on in 2013. So there are lots of reports and so on and so forth. Two of which deserve particular attention. So there was something called the Rose Report, which was an internal person averting to disclosing within the post office, I think, the issue of remote access. So saying, remote access is possible. And that's the reason that's important is that if I'm prosecuting you for the results on your computer terminal, saying you're responsible for it, you have a very good line of defense. If you can say, hang on a minute, somebody else had remote access to it. And the post office routinely denied that, actually more or less up until the Bates trial, partway through the Bates trial. And the Rose Report indicated that was possible, and that wasn't disclosed to defendants. And the Clark advice, so barrister brought in, because the post office essentially started to worry about what Second Sight, so there were independent investigators called Second Sight were brought in under pressure from some of the MPs banging the drum for the sub-postmasters. The Second Sight had started to find out lots of problems within the system and the approach to the prosecutions, and the post office seemed to have brought in a firm of solicitors, and Mr. Clark was a barrister working for them, to advise on some of that. And he gives an advice which essentially says, looks like this witness's evidence is misleading, and we need to now go through a process of reviewing all the cases and disclosing and so on and so forth, and advises in quite robust and strong terms about that. And that's at the end of July in 2013. And then there's another advice from the same gentleman dated, I think, 2 or 3 days later, anyway, early August. And that advice refers to an attempt to shred records within the post office, or an instruction to shred records being given by the director of security. So somebody quite high up in the post office, and the director of security, that department was the department that conducted the investigations. So Mr. Clark writes an advice which one might describe as quite angry, I think legitimately, certainly quite stern advice, saying actually this amounts to abrogation of the prosecutor's duties. So you're failing to honour your obligations as a prosecutor, and it may amount to a perversion of the course of justice. And he puts that in slightly gentle terms, but he's saying, this actually might be a criminal offence. Now, to be fair to the post office, they're saying actually nothing was shredded, but there was that instruction to shred from a very senior employee, and Clark advises on that too. So you have those two things going on in 2013. And now a defence lawyer, I think, would say, after having seen those things internally, they should have disclosed to all sub-postmasters the information about the bugs and the information about remote access, because all sub-postmasters whose cases were based on Horizon had reasonable grounds to doubt the safety of their conviction, all of them, hundreds of them. And instead, a more limited review was undertaken, apparently limited to cases from 2010 onwards, because one of the bugs was discovered occurred in 2010. So that's the reason they took that date. And I think disclosure was made, some sort of disclosure, it's not clear what that was made in a handful of cases, 20 odd cases. So after all of that, and there were other reports, Detica reported on the system and other things going on, Second Sight reporting in the background too, all sorts of things going on. And yet after all of that, only a handful, a couple of dozen, if you like, cases, or slightly more than that, got some kind of inkling that there was a problem with their original convictions. And that's something which the post office gets to 2021, whenever Hamilton's hearing was. I've forgotten the dates now. And they hold their hands and say, we can't defend this.
So disclosure, the failures of disclosure are on two levels, aren't they? One is when they're actually asked to disclose something, they weren't disclosing it. They didn't part with the information. Then there's stuff that nobody even knew existed that they don't reveal to anybody. But
that's right.
Judges were clearly deciding not to pursue the issue of disclosure. They were saying carry on with the trial without it, which does seem extraordinary, really. Do you understand that at all?
I think so. And here's, if you like, one of the ways in which the post office case may be a kind of symbolic or a particularly bad example of things that go on more generally with clients who aren't as sympathetic as, or defendants who aren't as sympathetic as the sub postmasters, to go back to one of the points at which we came in, which is that prosecutors and judges can be quite dismissive of the rights of the defendants in these cases and regard it as a stalling tactic or a delaying tactic. And that coupled with the idea that computer evidence tells you what you think it tells you, it is regarded as safe. And so those are the only explanations I can think of. Judges also have pressure to get through their lists to finish their cases. So don't like to adjourn, and because they're always being asked to adjourn cases for good reasons and bad. So there's a whole bunch of quite mundane pressures which push the judges in those directions. But to evaluate whether the judge got it right or wrong, you'd have to go back and read the transcripts and think about what was. And I haven't done that, but it does feel like a decision which was a really significant error. Certainly looking back on it.
And looking at who's representing the post office in terms of what you've just said, I'd be terrified, I think, if I had been one of those people now, because I would be thinking somebody's going to be knocking on my door, because it would seem, I've tried to cover something up. I've maybe even, conspired with other people to cover something up. I'd be really worried.
I think you'd be right to be a bit worried. Yeah. Because let's be honest, this is a very serious miscarriage of justice. And actually, although none of the lawyers would really think like this, if one was being supremely good about it as a profession, would say, actually, yes, my conduct, my handling of this case does need investigation because I was part of. So in that sense, if you're being virtuous about it, then one would think that. We don't know what they were told, what their instructions were, what they should have been thinking about, how they were managed, all those kinds of things. So they will get. And that's true of the Bates litigation and so on and so forth as well. All of this, we don't know what they were told, what they understood, how far they should have looked beyond their instructions and so on, and challenged and thought independently. All those kinds of things are questions which we just don't know enough about. But you do. There is a sort of there comes a point at which some alarm bells should have been ringing, and we do know sometimes. And sometimes the other side of this, which is interesting, which we don't know a lot about, is the cases that didn't proceed in this way. So some cases we do know. So one or two people who have been acquitted are quite prominent. So you had Nikki on your
absolutely
on your interviews, for instance. It would be interesting to know quite why their cases were different, and it may be sometimes the personnel were different, which would be really interesting. People who prosecute, who instruct people who prosecute, have ways of managing their prosecutors. So if you don't toe the party line, you won't get instructed again. I'm afraid to say that's a real problem. I'm told. I don't know if that was what was going on here, but that's a real problem.
My definite impression of Nikki, though, is that she was not going to plead guilty. Nothing you said to her would make her plead guilty. And she was not going to pay them a penny of money, even though they said she owed them money. And I think she was steadfast in that. And I think it's that makes her very unusual, I think, actually, Richard. Because I think a lot of people do take advice, and if they're told, the best thing to do is to plead to something, I think most people do it. I think she was offered that, and she was emphatic. No way was she going to admit anything.
Yes. Well, and you'll have had experience. You said you'd practiced criminal law. You'll have had experience of clients who are like that, clients who are much more go with the flow that their lawyer advises them. And you'll have heard the clients who are saying protesting their innocence, but also wanting to take the plea, and you know how you're supposed to deal with that. So the there's all sorts of interesting questions about the if you like, the makeup of the sub postmasters impacting on how these cases were decided. Also, sometimes the impact of the prosecutors or defense lawyers on the cases, I suspect, sometimes had some impact. So you've seen one or two cases where the prosecutors just sort of said, this is, this can't be. There was that very interesting account, I think it was Nicky's interview, wasn't it, of the conversation between the prosecutor and where the prosecutor said we're in enough trouble already. And that was the end of the case. Was it not her? Where did I hear that then?
No, nobody seemed to soften at all with her, and she just ended up having a bundle thrown at her.
Wasn't having it. That bit, yes. The kind of the disclosure mysteriously appeared. Yeah.
Tragically, she suffered as much illness and distress and damage as the people who were found guilty. So she gained morally, but she lost very heavily in spite of being acquitted, which is tragic.
Well, because I know there's no resolution for her, is there? There's no affirmation of her innocence. She was just found not guilty. She's obviously not been compensated either, and she's had no account of what's gone on, which can say, well, these people were responsible for what, and seen them dealt with. She's had none of those things, which might give her some closure. So I can well understand why she would be really badly affected by being accused of this kind of awful thing, and only getting partial justice through an acquittal gained partly through her own bloody mindedness. If we put it in the nicest, I mean that in the nicest way. Through her own strength of character, but actually the system was working against her all the way through. That process is, I'm sure, how she would feel about it, and that's how it looks from the outside in many respects.